Thank you very much, and good morning, everybody. It's a great privilege to be here and to have an opportunity of talking to so many people from so many different jurisdictions and parts of the US. I am going to pick up the proposals in the Green Paper towards the end of my comments and try and give some colour to the approach that I think is being adopted by the European Commission, led by Michel Barnier. But let me start, if I may, by discussing, as the programme I think indicates, the threats that exist, and then move on to the trends that I think are developing. My aim, let me say, is to try and speak for sufficient time that leaves an opportunity for Q&A. So if you think I'm running on too long, start waving your hands and I'll try and speed up. Let me start by emphasizing that I think that this is a very unusual and critical period for the accounting and the auditing profession. And you can tell that from the quite exceptional degree of public and government interest in the sector. We have in Europe significant consultations with a view to legislation or regulation in the areas of corporate governance, where there is even question marks about the effectiveness of boards of directors as currently constituted, over financial reporting, where there's concern about the adequacy of accounting standards, and in relation to audit, where, as I've just mentioned, Professor Michel Barnier is undertaking literally a root and branch review of the whole of the role of audit in the public sector. Internationally, IAASB has recently published two, I think, very important papers, one on audit quality and the other on audit reporting. The latter, of course, ties into the concept release that you heard more about yesterday from the PCAOB, relating to what should be included in the audit report in order to give greater transparency and information about the audit process and what users should know about. And in the UK, there have been parliamentary committees. We have investigating the role of the auditors in the financial crisis. We have an OFT review of whether or not the structure of the profession should be reformed. And the FRC, the Financial Reporting Council, has published a thought piece, a consultation paper entitled Effective Company Stewardship, which raises and addresses quite a large number of those same issues. So I think we face a sea change at the present time. And I think that sea change is for a very simple reason. For the first time for many, many years, financial reporting and the role of audit is recognized to be affecting all members of society. For years beforehand, it's been an erudite, technical issue that has concerned analysts, professional investors, accountants, company leaders, and so on. But the financial crisis saw financial reporting affect pensions, savings, investments. It saw it affecting the man in the street in a way that it had never done before. And as a result, the discussion has changed from the technocrats to the media, to politicians, to public commentators of all kinds, whether it's in the television or the newspapers. And this has, I think, fundamentally changed the environment in which the audit profession, the accounting profession, faces the future. I don't think in the future you will see it left to the technical issues discussions amongst people who are already experts. So against that background, I think there are some quite considerable threats to the profession. But just before I turn to those, let me make 5 points by way of introduction. The first is that I think audit must be seen in its proper context. It's not a sole self-contained issue, it's part of corporate governance, and it can't be separated from the responsibility of the board of directors for the management and governance of the company. It can't be separated from the management's responsibility for their stewardship of the assets of the company. It can't be separated from the responsibilities of the Audit Committee for the quality of financial reporting and for their oversight of the reporting process. So you can't address audit in isolation, and nor should one, in my view anyway, substitute auditors' judgments for judgments of the company and the company's management. The second point to emphasize is that shareholders actually delegate the responsibility for managing the assets to management. They don't delegate that responsibility to the auditors, and it's important to bear that in mind as we analyze the threats and the way in which they should be addressed. Thirdly, corporate reporting needs to be looked at on a holistic basis. Financial statements are part of the whole process. They're part of the annual report. They are not the whole of it. They don't define all of corporate reporting, and it's important as we look forward that the whole annual report should be fair and balanced. Fourthly, our whole structure is dependent on the way in which shareholders, investors, play their role. They are the arbiters of whether management are doing the right things, whether auditors have done a good job. They are the people who put those people in places of authority, and that key role needs to be focused on and developed, and they cannot abrogate those responsibilities and simply turn and say, well, the auditors should have found this or the auditors should have found that, and not have regard to their own role in the overall direction that the company takes. And lastly, by way of introduction, I want to emphasize that I'm speaking in the context of listed companies, public interest entities, and not the small companies that play such a big part in each economy. This is a real challenge because we live in a world where an audit is an audit, where there aren't differential audit requirements, differential standards, differential ethical standards, depending on the size of the company or the size of the firm carrying out the audit. Just to make the point about how important this is, in 2010, 99% of all enterprises in the UK had a turnover of less than 1 million euros and less than 10 employees. Yet those companies accounted for 59.1% of private sector employment and 48.6% of the private sector turnover in the UK. So the balance there is huge and the contribution very substantial, and it's very important that we don't lose sight of those interests. The current debate, I think, has 5 elements. The purpose of audit, and indeed whether it's fit for purpose. What I call the black box syndrome, the lack of transparency about the audit. Audit quality. What is audit quality? How is it to be assessed? Fourthly, professionalism, objectivity, independence, professional judgment, skepticism. And lastly, the market structure. And I'm going to discuss each of those in turn, touching on the different proposals under examination, and offer some suggestions at the end as to how each may be addressed and how we could go forward. So let me start with purpose of the audit, or fitness for purpose. I think it's important to bear in mind that as far as the UK is concerned, the audit was developed over 150 years ago. And those were different times, and audit was intended to play a different role. In the US, the audit was designed and introduced a little less than 100 years ago, but that was in the context of securities and the interests and effectiveness of the securities markets. Both of those environments have dramatically changed, at least as far as public companies are concerned. For example, companies are no longer the same sort of size as they were 100 or 150 years ago. They're now global, some of them the size of huge countries, and with the GDP of which takes them into the top 10 in the world. We deal now with computers which provide an accuracy which didn't exist 150 years ago. 150 years ago, mathematical accuracy was an issue. That was a challenge. Whether or not people added up the columns correctly was open to question. And that has all changed. Now, with a bit of luck, you buy a book in Barnes & Noble, and by the time you have that you've paid for it. It has already gone through the computer system and been included in turnover and probably contributed 0.00001% to the profits of the company. It's automated in a way which avoids a great deal of the role that audit played originally. But the one bit that hasn't changed is that it is a commentary on the stewardship of the company and to shareholders. So that remains a key point. But for fitness of purpose, the issues are different. Timing causes a problem. The audited accounts come out considerable time after the year end. And in reality, their significance in the listed sector has been overtaken by preliminary announcements and other discussions with analysts. The market already knows and has already decided, well, it made its judgment on the performance of the company long before the financial audited accounts come out. The accounts look backwards. They provide a historic report and on past stewardship. Yet in reality, people are now more interested in what the company is going to do, its prospects for the future, whether its strategy is correct, and how that strategy is going to be implemented. We use terms like reasonable assurance. People don't understand what reasonable assurance means. The lay person doesn't. And it's complicated because it's different for different individual line items. What does that mean for the whole accounts? And if you ask somebody how to define reasonable assurance, and I was asked to define that about 20 years ago, you come up with an unintelligible definition that includes phrases like the inherent limitations of audit, you introduce materiality, you talk about risk-based issues, assessments, and so on. And the challenges about the fitness of purpose for audit is compounded, I would say, by the black box syndrome, as I've called it. There's a total lack of transparency about what's involved in audit. It's a binary report, pass or fail. Sadly, we didn't, when the opportunity arose 30 years ago, go down the route of producing a more qualitative and discursive report, and a pro forma format became the norm. There's no commentary that the market can get their teeth into and decide, form a judgment about. The work, the analysis, the debates, the judgments that are made by auditors in the course of an audit, all of that is invisible. And worse still, audit successes are never, ever seen. Errors are corrected, frauds are pursued by new management or old management, but if they're found by the auditor, when did you ever see the auditor given credit for having discovered the position? The last thing in the world the company wants to do is to acknowledge that it didn't find it and that the auditor did, so the auditor gets no credit. So when we're looking at the role of audit in the current environment, we need to understand and recognize that this lack of transparency fundamentally undermines the recognition of the value of audit and also, frankly, confidence in the audit. And then we come to audit quality. Audit quality is constantly questioned, and it's a difficult issue. How do you define it? How do you measure it? The US Treasury Committee recommended that metrics be used to assess audit quality, and there was a day and a half, 2-day discussion about that with the PCAOB Standing Advisory Group, which started with an expectation that there would be definitive, observable, measurable metrics, and concluded at the end that that was almost an impossible task. When you ask people what audit quality is, it's very difficult. Some of you may remember that Peanuts, the product of a man called Schultz, if my memory is right, used to have a cartoon which was entitled Love Is. And in the space of 3 boxes, he would encapsulate what love was, or is, hopefully. And the fact is, if you do that for audit quality, it's extremely difficult to produce a succinct definition. In the course of the PCAOB discussion, people suggested that audit quality was getting an audit done to time and to budget. Well, I doubt very much if people in this room would agree with that. Some said it would indicate a good audit or audit quality was indicated by whether or not there was a need for a subsequent restatement. Again, I hope very much that wouldn't be a test that people in the room alone would judge appropriate. Because there are many facets to an audit that come into the assessment of whether it's been done to a quality standard. The thoroughness of the review, the exercise of judgment, the professionalism of the way in which the matters have been addressed, and ultimately, of course, whether or not it's free from error or misstatement. But that's not really enough. Professional judgment is the key element to a quality audit. And in the financial crisis, we saw that in a number of different ways. From the financial crisis, the work done by the UK in reviewing specific bank audits, AIU investigations and the like, inspections and the like, the noticeable thing was there was no failure to comply with audit standards. I'm sure there are things that could have been done better, but there were no criticisms that were laid at the door of bank auditors. But nevertheless, the consensus in the UK and in Europe was that audit failed in the course of the financial crisis. Why did it fail? In the view of politicians and the media and public generally, it failed because there was thought to be inadequate skepticism, inadequate exercise of judgment, with the result that there was too much focus on mathematical calculations of values in a turbulent market which required a much more, if you like, judgmental or mature approach to how provision should be addressed and how the affairs of the company should be assessed in that turbulent environment. And looking back on it, I think most auditors will recognize that there was an opportunity to actually turn around and ensure, not that the auditors said these are the issues that should be focused on in the future, but they should have ensured that the company gave a better explanation of the implications of the financial crisis to the future of those companies. And why do we have this problem? I think because there is probably great difficulty understanding the sophisticated nature of business in the modern world. The businesses that that are so critical to the various economies are huge, incredibly complex, and they require a very sophisticated understanding of the nuances of the individual work that's being done. And this, of course, is particularly true in the financial sector. Secondly, I don't think audit nowadays provides the same opportunity to, if I may use this expression, kick the tires. Much more time is spent behind computers, much less time is spent talking to management, talking to the people who are central to the way in which the business is undertaken. And if you talk to young accountants who are just starting out in the world, and I do because I have friends of my children who are starting out as accountants, they always tell you about the hours they spend behind their computers and not about the experiences that they've had going out and talking to people in the business. So I think the profession needs to understand that it's not sufficient simply to comply with standards. It needs to add value. And in doing so, it will have to face up to the fact that it needs to give hard advice to its clients and to understand that hard advice is invariably valued. Independence was the fourth of the points. And audit quality is invariably linked with independence. I personally have no experience of actual audit failure through lack of independence or objectivity. But it is invariably the case that people identify the closeness of the relationship between the auditor and the company as being something that impaired or impairs audit quality. The problem is exacerbated by the way in which many people use language. When you talk to an auditor and they talk about their client, they almost always refer to the company's management, and they don't refer, they're not referring to the shareholders or to the audit committee. They talk about corroborating management assertions, and that is it gives exactly the wrong impression when the role is to challenge management assertions to ensure that they're validly and properly made. As I've said already, the profession gets no credit for finding problems, and unfortunately that I think extends into the firms themselves as they try to manage their business. And lastly, of course, we have the issue of non-audit services, where there's a very confused debate, because many non-audit services must in fact be done by the auditor, and for many others, they're perfectly acceptable, provided they don't impact the audit itself. But unfortunately, the business of the profession overtakes the profession element of the profession, the professional ethos. And too much non-audit service work will always undermine confidence in the independence and objectivity of auditors. So I think that's another area to be focused on. Turning now to market structure, there are, I think, two principal issues. The risk that four major firms, the big four, will turn into three major firms, and indeed the concern that that will then lead to others to leave the market. And secondly, and in my mind much more seriously, the level of concentration in the sectors, in particular sectors, such as insurance in the UK and banking in Spain, and the level of geographic concentration that occurs in certain jurisdictions also. The risk of four firms becoming three is, I think, primarily an issue of regulatory intervention. We saw it with Anderson, we nearly saw it with KPMG, and the reality is that there are a limited number of jurisdictions which are so significant to the big unit that it will actually bring the unit down. Japan and India have already been shown not to be markets which are so significant that a solution can't be found. But having said that, certainly as far as the UK is concerned, there is concern to ensure that there are relationships and lines of communications between regulators and the big firms to ensure that they don't end up by getting on the wrong side of the regulatory line. Now, this is an area which is of particular concern to the European community. Michel Barnier has really focused on what he sees as the vice of the structure of the audit profession. And he is frustrated, bluntly, by the fact that he has not been able to get the competition authorities in Europe to take on that challenge and investigate the profession and then make recommendations as to how the profession structure should change. And his reaction to that has been to look for regulatory interventions which are capable or would have the effect of restructuring the marketplace. And that is why he proposes, amongst other things, joint audits, which are in the course of which one is required to have a firm that is smaller than usually the big four as the joint auditor. He believes that that will give an opportunity for those smaller firms to gain the expertise, gain the reputation and standing to be able to compete with the big four. He believes in retendering on a periodic basis. His period is, I have to say, quite short. He talks about 3 to 5 years, and he talks about mandatory rotation. On the retendering, it would be mandatory that firms outside the big four were involved in the tender process. He's raised the idea of audit-only firms, firms that do literally no other work other than audit. If that was to happen, it would necessitate the spinning off of the audit practices of the big four firms, and it raises quite interesting questions as to how they would have the expertise to deal with the more sophisticated and complicated areas that are currently generally supported by, for example, actuarial skills departments, people in the tax department and so forth. And lastly, he's contemplating a total ban on non-audit services. Again, that is driven by a belief that that will open up the market opportunities to firms outside the big four and thereby restructure the marketplace. His aim ultimately, and his belief, is that the structure of the market should be changed so that we don't rely on the big four, but we rely on something more akin to the big six or the big eight that we used to know. He is not driven by audit quality in making these proposals. He believes that The concept of a joint audit provides the opportunity for, as he calls it, 4 eyes, 2 sets of eyes looking at the judgments that are made. And he is persuaded by, I think primarily by experience in France, that that is a good, will work well, and therefore be a good protection of audit quality. He's not persuaded by the arguments that are being advanced by the profession, and he's not persuaded particularly by the arguments being advanced by companies. Both of those, but in both cases, that is because he sees them as self-interested arguments and driven by the individual interests of those constituencies. He's also driven by one other thing, which I've personally found, and I met with him to discuss these about 3 or 4 weeks ago, these proposals. I was also struck by the fact that he is very, very keen to come up with proposals which every member of the public will be capable of understanding. And that's behind a lot of his desire for what I would describe as a simple, easily explained approach to the solution to the problems. Unless there be any doubt about it, he's absolutely committed to reform, and he frequently uses the phrase that the status quo is simply not an option. But after those probably somewhat concerning, depressing, demoralizing, anxious-giving comments, let me just add that there are quite a few steps to be gone through before Michel Barnier's proposals become law in the European Union, not the least of which is to get it through the council, his proposals through the Council of Ministers. And we know for a fact that most member states are considerably concerned at the effect of these proposals on audit quality and whether in fact they are deliverable, they will deliver what he's aiming to deliver. So I think there's a long journey to go before they will actually take effect. And indeed, that journey will start in November with the publication of some specific proposals as to containing the actual changes which he would propose to implement. And the debate will then start both privately and publicly. And personally, I think a lot of these proposals will founder in the course of that approach, that debate. Having said that, I still do feel that there will be change and that we will have to be very careful to ensure that those changes don't adversely affect audit quality. I said that when I had outlined the threats, I would turn to trends or the way forward as I see it. And again, if I may, I'll take each in turn. The purpose of audit. I think it's vitally important that we create an environment where financial reporting, the financial reports for the past year, are seen in the context of a total annual report. It's absolutely right that there should be a report on the past stewardship of the company, because not least because that provides the foundation for all sorts of aspects of company activity, payment of dividends, the operation of bank covenants, the basis of raising new equity or loans, and many other such areas of corporate activity. So that is important. The continuation of the historical financial reports and the auditing of them is important. But it's vital that the annual report taken as a whole meets the needs of users. And to achieve that, we need to remove the clutter that currently populates annual reports. We need to concentrate on what really matters, the business objectives of the company, the challenges it's going to face in achieving those objectives, and the risks that will occur, and how those risks are going to be met or managed. It must, of course, describe its operations and set out its performance and how it's going to improve its performance. And the annual report as a whole must be complete, neutral, and balanced. It's only in that way that we will have an annual report including the financial statements, which enables users, especially shareholders, to make an informed assessment of a company's performance and its prospects. And in the course of doing this, hopefully we will make annual reports more readable, and the 450 pages or more that are currently the norm for big companies will be reduced to something manageable and readable. As regards what I called the black box syndrome, it is, I think, incredibly noticeable that the US, ISSB, the European Community, and the UK all seem to be looking at the same issue, namely, how do we get greater transparency about what is important or what was important in preparing the financial accounts and giving and securing a clean opinion. The US, as we've mentioned, through the UPCAOB, has a number of ideas relating to the structure of the auditor's report, using the emphasis of matter paragraph more effectively, even having a separate auditor discussion and analysis section. In the EC, there are similar ideas being discussed through the Green Paper and through corporate governance generally. But in the UK, the focus is on using audit committees. And I just want to spend a moment on this because it is quite striking that whilst there is agreement as to what is critical, namely discussion of the judgments that were made, the assessment of the appropriateness of the accounting policies, whether impairments were appropriate, whether estimates are correctly structured, assessed, and so forth. All of that is common ground, and the work that the auditors have done is recognised as being very important and must be discussed or disclosed. The UK does not believe that should be disclosed by the auditors. It believes the Audit Committee should report on the key sensitivities and the risk matters that the Audit Committee, and therefore the company, believes shareholders should know about. It believes that the Audit Committee should discuss the key judgments and policies that were made in relation to those estimates and provisions. It believes it should explain, the Audit Committee should explain the approach it's taken to its relationship with the external auditor about appointment and reappointment, about the use of the auditors for non-audit services. And there are 4 reasons why we believe in the UK that the Audit Committee is the right body to provide that information. First, shareholders want the company view, not the auditor's view. It's the company that they, and to the company's management, that they delegate responsibility for the assets of the company. Secondly, the company meets shareholders on a regular basis. It's involved in discussions with the marketplace. It's the company, therefore, that understands what people are sensitive to or concerned about. The auditors are not part of that discussion, so they're not so well attuned to what the market wants. The company, and this is very important to our mind, the company will talk about these issues from an individual perspective. It will not resort to, it should not resort to standardized language. Whereas we already know that the auditors will be concerned about language arbitrage, whether people will interpret language differently in different reports, and therefore there is a high probability that auditors will move towards standardized language again, and therefore defeat the very objective of this greater discussion. But I accept, and the UK accepts, it's not sufficient for the Audit Committee to be the sole providers of this information. The auditor needs to report on whether or not all the key issues have in fact been discussed in the annual report. And it needs to provide a conclusion on whether or not the annual report, taken as a whole, is fair and balanced. And if we do that, then the auditors will provide, as they do in relation to historical financial statements, provide a check on the integrity of the whole process. Audit quality. Audit quality is not, I believe, a product of standards, and standards aren't the solution to the issue. They've, in my view, progressed substantially as far as they can, as far as is practical. Of course, there's more that can be done to learn from experience and tune the auditing standards as we learn from failures and audit inspection. But I really do believe it's unlikely that audit standards can be transformed or developed in a way which will result in audit standards determining audit quality. And that's for 2 reasons. First, because auditing standards cannot ever address every issue or challenge that auditors encounter. And secondly, because the key issues nowadays are about judgment, about the appropriateness, as I've said, of accounting policies, the adequacy of impairment provisions and estimates for future outcomes. So audit quality will depend on professional education and training, mentoring by those with experience, and we should ask whether the way in which we educate accountants is appropriate in the current environment. Education doesn't extend only to understanding accounting standards, understanding and knowing auditing standards, understanding and complying with ethical standards. Education needs to focus on developing the right mindset, a mindset that is appropriately skeptical, that challenges the information that's provided and helps people understand how to challenge that information, provides the sophistication of information and knowledge that enables them to understand the businesses that they are then going to be involved in auditing. Independence. Independence, I believe, needs to be removed from the debate. We need to differentiate between audit-related services and non-audit services. Many services that are provided by auditors are audit-related services. For example, a report under Sarbanes-Oxley is an audit-related service and quite patently should be provided by the auditors rather than by someone else. But there are many such examples. But there are also non-audit services, services that could quite legitimately be provided by others. In the UK, we've tried to differentiate between audit-related services and non-audit services. We've gone further and required in the combined code, the corporate governance code, that audit committees should describe their policy in relation to the provision of non-audit services by their auditors. We've also required them to indicate the relationship in quantum terms, the fees paid in relation to non-audit services as compared to the audit fee, to see the extent to which the firm will regard the relationship as driven by the audit relationship or the non-audit services relationship. All of that we've done with a view to generating more confidence in the position. But frankly, it looks as though that may not be enough. And one of the things I think we will need to consider is whether or not one reverses the burden so that the burden is, or the approach is that auditors do not provide non-audit services unless there is a really good reason why they should, which the company's management is prepared to go public and explain to the world outside. Further, in relation to the relationship between auditors and their clients or their companies, we're looking at whether or not there should be a requirement to tender at least every 10 years. Note, I said tender, not rotate. But the process of retendering will, we believe, first of all, encourage shareholders that there is not such a cosy relationship that between the auditors and the company's management that they need to be concerned, but it will also provide opportunities for other firms to compete for the work. As far as the structure of the marketplace is concerned, we don't believe, and I don't believe, in using regulation to address competition concerns. We therefore don't like the approach that's being taken in Europe in relation to by promoting joint audits. We're concerned that that will affect audit quality, and we can think of nothing that should be more damaging to the confidence in financial sector in particular than to have a situation where a company is being audited by somebody who patently doesn't have the experience and expertise to audit the financial services sector company around the world. So we are genuinely concerned about some of the proposals, as I've indicated, in Europe. My final thoughts are just one other point, really. If the profession is going to be the profession that it was when I first started working, it definitely needs a vision for the future. That vision needs to be built not on the business of providing accounting services, but on the role that the accounting plays in society. When I started in London in 1970, when a company had a problem or an opportunity, the first person that was turned to was the partner in the accounting firm who looked after the relationship between the company and the accounting firm. he was the first person management turned to and asked to express views and provide advice. Second, the company would turn to investment bankers to help them with a sale or a purchase or raising money or whatever. And lastly, and without any doubt at all, right at the tail end, the lawyers would be asked to document the transaction. In 2010, the opposite is almost exactly the case. The first people that are brought in by the company are the lawyers, mainly because they're not seen to have multifaceted interests in how the transaction or issue will develop. Secondly, investment bankers are brought in, and as many of you will know, most of the investment bankers, the very big investment banking firm won't be relied on for the merger advice or transactional advice. That will be with a boutique like Greenhills or someone of that nature, or Rothschilds. And I have to tell you that in the last 15 years of practice, I haven't been at a critical board meeting when the partner at the accounting firm has participated in the discussion. Sure, the accounting firm will have done a lot of work behind the scenes, working with management in developing the numbers and developing the documents. But when it comes down to the judgments that were going to be made by the board of directors, as I say, I have not been at a board meeting where a big decision has been made and the accountancy firm has been represented. When I started, people like Henry Benson, who was the senior partner at Coopers, was called in by the government when they had to make a decision about whether to put Rolls-Royce into liquidation. Big issues of the day always involved the leaders of the accounting profession. And sadly, that isn't the case now. So I feel very strongly that if the profession, as a profession, is to have a future, then it has got to have a vision as to how it's going to make that contribution. And that needs to be led by the profession, because I don't believe it's for regulators to set that vision. And I hope very much that there will be an opportunity for the profession to provide leadership in the future to frankly, an environment which is more rewarding for the young, more encouraging for those who, and provides better job satisfaction than the current very critical environment in which it operates. Thank you very much, and I'm very happy to answer any questions if you have any.
Richard, thank you for those comments. That was very insightful. We talked about joint audits very briefly yesterday, and I believe someone commented that it hasn't worked. Was it somewhere in Canada? I remember that comment. But anyway, that's obviously a strong proposal of Barnier's, and I'm just wondering, he refers to the success in France, but how has he or how have they determined that it really is successful, that joint audits really do achieve the objective that's been set forth? Can you expand on that a little?
I think it's an exceptionally good and difficult question. As I'm sure most people in the room probably know, there is a particular firm that's based in France, Mazars, which has made a feature of being involved in joint audits and has grown substantially as a result of doing so. There is some considerable debate as to whether the effect has been as successful as it is claimed to be by those who advocate it. Mazars obviously are great proponents of joint audit as a means of opening up the marketplace. If you talk to different people, you will get different views. And there seems to be a great deal of nationalist drive for this current initiative. If you talk to French firms within the networks of the Big Four, you will get very varied reports on the effectiveness of the joint audit structure as currently operating in France. But there are examples, in all fairness, where it has worked very well to a degree. And the great question is the extent to which it is truly a joint audit, or an audit that is being done by two firms where they do different things and they come together at the end? I mean, is this a joint audit where they both sign off on the parent company consolidated accounts and do, broadly, 35 to 50% of the work each? Or is it a situation which I've heard some people talk about, where there's a joint audit at the top, but actually all the work underneath is done by one of the big four? How is the work split? And the result is that you get very different views from different people depending on their experience of how this is operated. It certainly adds cost, it adds complexity, it adds time, and therefore most companies are anxious about it. And it's not without its significance that most of the historically well-known joint audits, many of which actually originated from companies that are Anglo-Dutch companies like Shell, Unilever, and so forth, all of those have ceased to be joint audits for about the last 8, 10 years. I've lost track. So I think the evidence on the effectiveness of joint audits is very varied. But I think everyone needs to understand that what you're seeing is a fairly determined promotion of the French model in the political environment at the present time. And that it goes so far that it is generally understood, I can't say this is fact, but it is generally thought to be and understood to be the case that President Sarkozy has told Michel Barnier that he wishes the proposals to be discussed at the G20 summit at the end of October in relation to financial reporting to be based on the French approach to audit structure, i.e. joint audits, and the prohibition on non-audit services. And this is seen as part of the political environment in which this debate is happening at the present time. It makes for a very difficult environment.
Richard, thank you so much for coming. What a pleasure to hear from you. And I wonder if you might be able to paint us a little bit of a scenario as you see it, or as those in the UK might see it, about this notion of what would happen if we lose another firm. Because that is something if we were to lose another one of the big four, and not another one of the big four, but another one of our large firms, that, as you know, was something that the Treasury Committee had a lot of concern and debate over. How do you see that playing out? And in particular, this notion of an audit-only practice out there, how viable would that be? I assume that if we were to lose another firm, there would be almost an immediate collapse of independence because there's just not any options there. But maybe you could help us.
Well, we've spent a lot of time on this in the UK. The FRC, in conjunction with the government, commissioned a study by Oxera and put together a group that then tried to come up with proposals to try and reduce the dependency of public interest companies on the big four, frankly with limited success. And I suppose that in the UK, unless there is to be a law-inspired restructuring of the profession, we frankly believe that we are saddled with the existing structure of the big four, and the concern or the focus must be on avoiding that big four becoming the big three or worse. And the steps that have been taken so far include, first, the Audit Firm Governance Code. Now, I don't know how many people will know about that, so let me just quickly try and explain it. That is a code that the major firms now comply with, which provides, amongst a whole range of other things, that there should be some external, independent individuals of real standing whose role, amongst a range of other things, is to provide an interface of last resort with the regulators, regulatory community and the like. a lot of people felt that the Anderson saga wouldn't have developed the way it did had, for example, there been a person or persons of stature who could have been, the SEC and others could have liaised with at a much earlier stage in that disaster. And if you remember, in due course, it was suggested that somebody should come in and take over that responsibility, but it was too late. And built on that thesis, the UK has proposed and implemented an audit firm governance code which provides a group of people who are knowledgeable about the affairs of the firm, involved and have access to the leadership at the top level, and who are an interface potentially with the regulators and others and investors if there is a need or if there are concerns about the way the firm is going. That is one approach. I must tell you that part of the origin of that was somebody who's well known to many of you in this room, Mr. Lynn Turner, who had raised the fact that had that been around some years ago, it could have avoided some of the problems that were encountered. I don't know whether I could validate that, but I certainly have understood the thesis that he was arguing. The second thing that we are looking at, and hopefully I hope will be implemented, is either an agreement amongst the firms that if there is a collapse, that they won't act like vultures over the body in terms of personnel and clients. I mean, very noticeable when Anderson collapsed that what actually triggered the demise of the firm was, of course, the criminal proceedings, but it was the loss of confidence by the clients and the immediate recognition by the other firms that those clients were up for grabs. And so we hope, and we are promoting from the FRC and discussing with the OFT, arrangements which would effectively control the way in which a firm that was facing breakup was attacked by the other firms. For this reason, Galen, that it would then give you the chance to restructure the innocent parts of the firm and therefore create an environment where the fourth firm survived, bearing in mind that on most occasions these problems are local to a particular jurisdiction, and the rest of the network is likely to be there to survive in the future. So if you could reconstitute the problem in the jurisdiction where the problem exists, then you've got a future. And that, after all, is what happened in Japan with PwC. The third thing is that, and I don't know where this is going to go to, there's a discussion going on about living wills, i.e. a discussion about where the firms establish arrangements that will apply in the event that a regulatory problem of magnitude occurs. None of these are surefire to succeed, I have to tell you. I think the greatest discipline on the demise of a firm is ultimately that it's not in the public interest that that should happen, and hopefully people will therefore look at the situation in a way which is designed to preserve the firm and ensure that those who are fundamentally responsible for the problems are the people who bear the pain and the punishment that goes with it. But is there certainty on the subject? No, there isn't. And can there be? No, frankly, there can't be. Lots of people worry about litigation, the litigation risk. Of course, it's a real risk. The UK has recognised that. The UK has put in place a legislated regime that allows for contractual limitation of liability. Hasn't worked terribly well, not least because it doesn't work for SEC companies, SEC registrants. But at least the principle of a need to ensure that litigation exposure can be limited to something that's appropriate to the organisation has been recognised. I personally don't expect litigation risk in the UK to bring down one of the big four, because frankly, there is more value in a live company that pays a certain sum of money every year for 10 years than squeezing the stone for the last drop of blood. And everyone who followed the Anderson saga must be aware that Anderson would have been able to settle the Enron litigation for something of the order of 750 million while it was alive, and was only able to pay some 5% of that when it subsequently went into liquidation and the assets were realized. So I think that's a pretty good example of why litigation, any sensible claimant is going to recognize that putting the firm under for litigation risk is not necessarily in its best interests. I hope that answers some of your questions, some aspects of your question.
Since you appear to be a consular as well as having expertise in accounting, in the U.S. we do not yet have the multidisciplinary practice of law and accounting, but I do know that it's alive and well in the European Union, and I believe in UK. Has this movement created any additional independence problems in fact or in appearance, and how have the firms dealt with that?
Well, multidisciplinary practices in Europe probably, well, they had a big setback after Enron and WorldCom and the problems that then ensued from that. But it's right to say that the firms have progressively rebuilt their consultancy skills, often under the heading of business advisory and other types of terminology. And very substantially, those practices now exist and provide a range of different services. And in other countries other than the UK, the multidisciplinary character of the firm is greater than anywhere else. I mean, they do practice law, they practice actuarial, the actuarial services, provide actuarial services, and so forth. At the end of the day, the provision or the relationship between those multidisciplinary activities and the audit function is disciplined, if that's the right word, by the ethical standards that exist in each particular country. Unfortunately, in Europe, there is not one standard, one code that applies across Europe, and there are differences in the way that this issue is approached from country to country. France prohibits all non-audit services, but then has a procedure by which they're permitted if they comply with a framework or a process that has been approved by a regulatory body, to make it simple. In the UK, we adopt a threats and safeguards approach, which is probably more rigorous than, for example, the code that's promoted by IFAC. Having said that, the result is that you have a number of different approaches through Europe. I think it's probably fair to say that's part of the reason why the non-audit service debate is alive in the European Union at the moment, because there is concern at the proximity of the relationship between the firm, the company being audited and its audit firm. And certainly they have a higher level of non-audit services, a higher proportion of non-audit service fees are attributable to a company in Europe than in the UK as compared to the audit fee. So in the UK, for example, non-audit service fees are about 0.63% as against the audit fee, but it's a much higher percentage across Europe. And therefore, there is a difference of approach to the appropriateness of the provision of non-audit services by the multifaceted, multidisciplinary companies, firms.
Okay.
We're running a little late, so I think Ray will be our last question. We'll move on to the next speaker. Rick, will you be staying after your session to talk to some individuals? Is that possible, or do you have to leave?
I'll be leaving in about an hour and a half, but
okay.
Yes.
So at the break, possibly, if some people have some questions?
Yeah.
Yeah, great. Okay.
I want to thank you for your thoughtful comments, and I'd like to solicit a comment. When I read the UK Green Paper, it seems to be flirting with the line between a financial audit and an operational audit. There seems to be a desire for an audit opinion, not just on whether the financial statements are true and fair, but about the business risk of the company. And I think that's a very different type of audit. Can you share your views on kind of how the European view on that line between what you want out of a financial audit versus an operational type audit?
Well, you're right that there is a considerable pressure to provide, whether from the auditors or otherwise, let's take it at that level for the moment, for there to be a greater transparency about the operational activities of the company and a provision of some comfort as to the appropriateness of the description of the operational activities of the company alongside the financial audit. And that has led to people calling for auditors to play a greater role in judging the appropriateness of that discussion. It's also, because we certainly in the UK do not believe that is necessarily the responsibility of the auditors. We don't believe that's what the audit is for. We do, however, accept, and that's why we propose that the audit committees should be the people who are responsible for describing the information which shareholders and other users are calling for about the operations, about the strategic objectives, about the risks that the company faces. We do, however, recognise that you can't stop there. Through their work as auditors, in reviewing papers, looking at the minutes of board meetings, looking at the affairs of the company, auditors become aware of information. And we accept that if they become aware of information which calls into question the way the company is describing those operational activities, then the auditors must stand up and be counted and can't be silent on the issue. So that is why the approach in the UK, recognising the concern that underlies your question, is that the audit committee should be the body that is responsible for providing the operational report, the operation information, and the auditors should speak up if they become aware of anything which conflicts with the way in which the company has described the position. So if, for example, a company has said, we've got no concerns whatsoever about access to funds for the next 18 months, and auditors actually know that they're in extensive difficult discussions to renew facilities in 3 months' time, the auditors can't stand silent in that situation. They've got to stand up and be counted. And that's the relationship that we see in the UK. I hope that helps explain the position.